So I welcome you guys again, everyone, for joining us here for Constitution Day at Jacksonville State University. Welcome to the Tocqueville Lecture Series. This lecture series is named after Alexis de Tocqueville. Born of the French aristocracy, Tocqueville examined the world to understand democracy. His investigations convinced him that liberal ideas, which rejected both the antiquity of aristocracy and doubted the promises of the French Revolution, were the progression of history. Whether individuals fought for or against these ideals, he was convinced that equality of conditions is a providential fact. This lecture series invites scholars, professionals, and civic leaders to present on the ideas of liberty and equality as they relate to other concepts important in the founding and continuation of American government. These are free and public lectures, which are hosted here on the campus of Jacksonville State University, and invite other institutions of learning and the surrounding community to come together so we can listen, think, reflect, and engage with each other. The Tocqueville Lecture Series is funded by a generous grant from the Jack Miller Center. The Jack Miller Center is dedicated to advancing education in America's history, its political and economic institutions, and the central principles, ideas, and issues arising from the American and Western traditions, which continue to animate our national life. In addition, the American Democracy Project at Jacksonville State University is co-sponsoring this event with us tonight. It's my pleasure to introduce to you Dr. Elizabeth Kaufer Busch. She is the Laura and Pete Walker Professor of American Studies at Christopher Newport University, where she also serves as the Director of American Studies and is the founder and co-director of the Center for American Studies. Recently, she was appointed to serve on the Civics and Civic Engagement Task Force for the U.S. Semi-Quincentennial Commission, also known as America 250, which was created by Congress to prepare for America's 250th anniversary on July 4th, 2026. There are a lot more accomplishments and other positions I could list, but I also want to start introducing you to Dr. Busch's research and the topic that we're going to be learning about tonight. In her research, she focuses on the role of civic education in supporting democratic institutions and good governance. She has also done extensive research into involving concepts of sex, gender, equality, and feminist thought, and the role those concepts have on public policy. She has published articles, book chapters, and scholarly studies on these subjects, and is the co-author of Title IX, The Transformation of Sex Discrimination in Education, which explores the non-legislative processes by which the law has been transformed over 5 decades. And she's the co-editor of Democracy Revisited, Essays on the American Regime. She is currently working on a number of projects, including ones that examine the constitutionalist creed as compared to the anti-constitutionalist culture, something that we'll hear more about. It's my pleasure to stop sharing my screen and to hand over the microphone here to our lecturer, Dr. Elizabeth Kaufer Busch. Thank you for joining us tonight. It is a pleasure to have you.
Thank you. Before he runs away, you'll notice we matched tonight because we both believe, you got to wear your red, white, and blue on Constitution Day. So we match actually quite well.
We do.
So, thank you so much for that really generous introduction. I'm always extremely impressed when someone can say semi-quincentennial, a term I hadn't heard of before this commission. It just means half of 500 or 250. Anyway, thank you for having me tonight. I'm talking on the subject of restoring Title IX's constitutional integrity. And this is a topic that has really grown out of a work that I'm working on called How to Be a Constitutionalist. Sorry, I'm just seeing if I can share my screen real quick here. Here we go. There we go. That's our topic for tonight. And this is really bringing together 2 projects. So the book that Professor Gross just mentioned a moment ago, The Evolution of Title IX and Sex Discrimination. And then my current project, which is called How to Be a Constitutionalist. That's a working title. I'll take suggestions at the end if you have any recommendations. So the premise of that book is that our society is currently divided between constitutionalists and anti-constitutionalists. So I'll define each term very briefly, and then I'll launch into Title IX. A constitutionalist, whether they're Republican, Democrat, or independent, this is not left or right wing, it's anyone can be a constitutionalist. They're committed to the ideals embodied in the US Constitution, such as equal rights protection through the rule of law. Rule of law is actually quite central to this, as well as what I call common sense principles designed to promote compromise. And some of these include the design of the Constitution itself, bicameralism, separation of powers, federalism, and legal traditions tied to the US Constitution. In a nutshell, a constitutionalist is dedicated to seeking the appropriate constitutional end goals, such as equal rights protection, and using the mandated constitutional means and processes. So following the rule of law and following the dictates of the Constitution. So then on the flip side, you've got anti-constitutionalists. Also can be on the left and the right. They tend to be more left or right, not so much in the center, but some could theoretically be in the center. They reject the Constitution's philosophic foundations and the institutional norms and legal processes designed to achieve those ideals. So I have applied this paradigm to Title IX in order to better understand the nature of our policy disputes. And what we see when we do that is that there are numerous examples of administrators in the Office for Civil Rights, and I'll talk about what that is momentarily, violating constitutional processes that are mandated. At times, they also violate constitutional end goals. I'm going to focus on the process, and then time permitting, we'll talk about the content. And in Q&A, there'll certainly be time to talk about content of any of these aspects of Title IX, if you like. So my thesis tonight is Title IX's constitutional integrity has been threatened by the movement away from what I would call legitimate lawmaking toward informal rule making. This is the main reason why Title IX is so controversial and why it has changed so much. So I'm going to now talk about what I propose to do in this time that I have tonight. First, I'm going to give a brief background history of Title IX's evolution. Then I'm going to describe the constitutionalist as well as the anti-constitutionalist method of changing Title IX, just for comparison's sake. And then I'm going to explain how Title IX has changed. And spoiler alert, there are only 3 changes that have been made formally, either by Congress or the Office for Civil Rights. Most of the most controversial changes have been informal and what I call anti-constitutionalist policymaking. And then finally, I'm going to close by talking about the ways in which we can restore the constitutional integrity of Title IX. And I'm going to invite us to think about how we could promote a constitutionalist culture. How can we promote citizens who care about following the law, even if it sometimes doesn't bring the end goal that they would like to see? So let's move on to the basics of what Title IX was envisioned to be, and what Title IX has come to be. Now, I'm just going to say a brief word about this picture that I have on the screen. You can see very slightly in the background, it says, "Bring me men." And that phrase comes from a poem, and this is the Air Force Academy. You see the first woman walking into the Air Force Academy years ago. They ended up taking down that sign, "Bring me men," when they desegregated it and allowed women into it. So we have the original Title IX, 37 words. And I have those up on the screen. "No person in the United States shall be, on the basis of sex, excluded from participation in, be denied the benefits of, or be subject to discrimination under any educational program or activity receiving federal financial assistance." So something first to understand about this is it is using the federal contracting program in order to compel behavior, in this case, non-discrimination on the basis of sex, being compelled whenever the federal government is going to provide money to an entity. Here we're primarily talking about schools and universities and colleges and K-12, that they can compel certain behavior as a condition of receiving that federal money. So non-discrimination. What we'll see is the concept of on the basis of sex has been disputed. The concept of what a program or activity receiving federal financial assistance has come under scrutiny over time. But initially, these 37 words banned intentional, purposeful, or, quote, invidious discrimination against females and males. It's not one-sided. It sought to eliminate, and this is a quote, preferential or disparate treatment to the members of one sex in admissions, financial aid, academic class, extracurricular programming, or other activities. Preferential treatment on the basis of sex would violate the statute's purpose, which is to eliminate and ban discriminate. Title IX permits affirmative actions, meaning putting into place affirmative programs to try to bring women into areas where they had previously not been permitted, but it does not require it. And that's actually quite an important point. From a constitutionalist perspective, the language of a law constitutes its meaning. And what that means is the public meaning of the words at the time the law was written. So I've looked at the congressional record, and the word gender is not used at the time in the debates, and it's not used in the statutes. So we have to look up the meaning of sex to understand what the law means. And in terms of this particular law following the World Health Organization, sex is a biological distinction. Later on, some of the prohibitions in Title IX come to include various forms of gender discrimination. And again, we can talk about that later. So you have the original meaning of these 37 words, and then let's talk about now. There have been a number of unanticipated changes. Some of the changes anticipated, expected, and hoped for. So my co-author on this Title IX book, and actually on my next book, his mother was a home economics teacher. And when she taught, no boys were allowed in the class. By the time I went to middle school and had home economics, it was completely mixed with males and females. And some credit Title IX for doing away with those male-only, female-only classes, that certain classes are meant only for males or females. You've seen an immense growth in the number of athletes, female athletes. So a 990% increase at the K-12 level of female athletes, because there were basically no programs. Maybe a half-court basketball was permitted on the female side. And then on the intercollegiate level, there have similarly been some really great advances. Some actually credit Title IX with our dominance in the Olympics over the last several decades. Unanticipated changes, parallel justice system to adjudicate campus sexual assaults. So I would say before 2011, before 2015, if Title IX was introduced, someone would say, oh, Title IX, you're doing research on Title IX, that's a sports law, right? Actually, no. You read the 37 words, you heard me read them aloud. It wasn't clear initially whether Title IX was even going to apply to athletics. And actually, a lot of big lobbying was done from the Big Ten schools because they didn't want it to have jurisdiction over football, for example. Now, later it does get defined to have jurisdiction over Title IX. And the way in which that is interpreted is in a very specific way. Numerical parity is necessary in athletics on college campuses across the country. And what numerical parity means is that your proportion of male and female students needs to be mirrored in the proportion of male and female athletes. So if you have a liberal arts college, which is primarily the type of institutions where I've taught in my career, say you have 70% female and 30% male. That's actually not atypical at a liberal arts school anymore. That means that 70% of your athletes need to be female as well. That was not anticipated. Another unanticipated result, over 800 due process cases against universities being brought due to the procedures they've put in place to adjudicate sexual harassment claims and sexual assault claims. When I started writing my presentation for today, it was over 700. And by the time I finished the presentation, it's now over 800 cases. And I think probably the greatest shock I've had in studying Title IX is the attempt to replace the word sex with gender and or redefine the term sex. So we will be talking about that later today. All right. So a couple of other basic points I want to make before I get to laying out these anti-constitutional means or procedures. So the method of enforcement of Title IX is called an administrative remedy. And what that means is, if you are at a university that receives federal funding and you believe there has been discrimination against you, you weren't permitted to take a particular class, or there aren't adequate athletic opportunities for members of your sex in a particular sport, you could level a complaint, and you would level that complaint to the Office for Civil Rights in the Department of Education. Previous to that, it had been the Department for Health, Education, and Welfare. In the 1970s, federal rollover education expanded, and they created a Department of Education. And so that is the entity today that enforces Title IX. So you would make a complaint to the Office for Civil Rights. If they viewed it as a credible complaint, they would come to your campus and investigate. They would determine whether a violation was made, and then they would make recommendations to your campus for how to remedy that. Later on, the Supreme Court adds to your rights the right to sue your university, just as a side note. Now, an agency like the Office for Civil Rights also has to determine what a law means, because, you know, you have 37 words. When these words were passed, it was also added as part of the law that Congress would have to improve what they called implementing guidelines, meaning, please write hundreds of pages and tell us what you really mean by these 37 words. So it took about 3 years, and the Congress approved the regulations, i.e., what this law means, as of 1979. And I would say the way to view this is there have only been 2 formal changes ever enacted by the Department of Education, previously Health, Education, and Welfare. The first is that 1975 regulation. And per the law, Congress approved it. And so from a constitutionalist perspective, completely acceptable, because you have Congress, your representatives who you elected, voting on the law. That is their constitutionally mandated job. If we were in a live audience, I'd ask you to guess when the second one occurred. So I'm just going to reveal and spoil it for you and tell you 2020. 2020 was the time that the second formal regulation. So you have from 1975 to 2020, the only two times that the Department of Education has used their mandated process and requirements to make a substantive change to Title IX. So remember that slide when I said then and now, right? Going back to here. And we see all those changes that have occurred, some intentionally, some unintentionally. Most of those things have not happened through a formal process. Now, let me add to this that there has also been one example of Congress making a major change to Title IX, and that is in 1987. Congress passed a law called the Civil Rights Restoration Act. You got to love how they title laws, right? In this case, they wanted to expand the jurisdiction and reach of this law so that any university who received even $1 of federal funding in any area on campus would have to have the entire operations of their university or college or school comply with Title IX. There had been a court case called Grove City v. Bell, and in that case, they had interpreted program receiving federal funding to mean only the programs receiving federal funding had to comply. Congress was having none of it. There was so much support for this that Congress overrode President Reagan's veto power at that time and passed it. And so two major changes by the Department of Education, the 1975 law and the 2020 law, was an alteration to how universities are permitted to conduct investigations when a student claims another student has sexually assaulted them or has engaged in some form of sexual misconduct or sexual harassment. The Civil Rights Restoration Act means basically every school except 14 in the country, and those 14 take not $1 of federal money, have to comply with Title IX. So a few more words about Title IX today, just to show the extent to which it has changed and expanded without Congress passing laws and without the Office for Civil Rights following a constitutionally required or mandated procedure. Today, students can invoke Title IX not only to get numerical outcomes in athletics, not only to receive protections against sexual misconduct, they can do so to play on the athletic team that comports with their gender identity. They can often receive monetary damages if a school fails to do so. There seems to be a violation within the law that it prohibited preferential or disparate treatment. There's a question in athletics whether that's being breached because schools receive punishment when they remove female athletics teams, but have not yet at the court level received punishment for eliminating male teams. And so there's been a question of whether that's preferential treatment. From my perspective and my focus, the most interesting aspect of what's changed over the last several decades, 50 years really, the due process rights of students have been violated by the Office for Civil Rights. And this is incredibly interesting, and it's happening right now too. So, and I'll say more about it in a minute. But I mentioned those 800 cases that are pending that have been brought by students against universities. They are being brought by students who've been accused of sexual misconduct, who are claiming that their due process rights have not adequately been protected. And again, I'll touch on this a little bit more about the consequences of that and how that's very timely and being discussed right now. But first, I'm going to talk about how these changes have happened and the anti-constitutionalist means by which they've occurred. A quick word on my images here. So the woman who's cheering after just ripping off her shirt, this is Brandi Chastain in the famous World Cup victory. She became kind of the poster child for Title IX and all it's accomplished for athletics. And this woman on the right, carrying the mattress, is a Columbia student who was protesting the way in which her university handled a sexual misconduct, sexual assault allegation that she had claimed against another student. That whole event ended in the student against whom she had made a complaint, suing the university and having an undisclosed settlement. So that was actually one of the 800 cases to which I was referring earlier. So by anti-constitutionalist means, and how has this happened? What I mean is this. Title IX can legally, constitutionally be altered a couple of ways, really three basic ways, and I've already mentioned all three. Congress can change it, right? Congress is the body mandated by the Constitution to make the laws. And making a law means they can change a law, they can repeal a law, they can add amendments to a law. They have not in the case of Title IX, except the one time I mentioned earlier. Sometimes the Supreme Court might alter a law. Judges may interpret a statute's text to ensure that it complies with the Constitution. And I'm not going to talk about the court's interaction here, but I will say there are a couple examples of the court acting in an anti-constitutional manner, and some good examples of it changing Title IX in a constitutional way. So again, in Q&A, if you want to talk about the court a little bit, we can, but not for the purposes of the talk. Now, the third way that I'm going to focus on is how appointed administrators in the Office for Civil Rights, previously Health, Education, and Welfare, these are people appointed in this agency that resides in the executive department. And their task is to enforce the law. And so, again, to enforce the law, you need to be able to say what the law means. So they can do that job by publishing what are called formal regulations. Now, there is a requirement that if you're publishing formal regulations, meaning this is what we are saying Title IX means, and this is how we're going to enforce it, you have to comply with a rule called the Administrative Procedures Act. And I know I'm losing some of you already when I start to talk about bureaucracy, but it's actually quite fascinating. Trust but verify. So listen, and then you can tell me if I'm actually wrong, that it's interesting. To publish a formal regulation, you've got to write your proposal, put it out for comment, and the proposal for how you're going to enforce it must comply both with the language of the law and with the Constitution. Again, be constitutionalist. What has happened and how some of the most groundbreaking, controversial changes to Title IX have occurred is they've used what are called informal guidance documents. In other words, they didn't go through that very time-consuming procedure where you open for comments. Just a case in point, the Department of Education has a comment out right now on Title IX. It got over 200,000 comments. Okay, so you have to sift through all of that and respond to all of those. So given that, you can understand why an administrator would find that rather cumbersome. And you could ask whether is all that necessary. And I'm going to argue that it is, and I'll argue why throughout this talk. But the most controversial changes, the requirement for numerical parity in athletics, the Dear Colleague letter on sexual violence and sexual misconduct, written in 2011, really came to be understood better in 2015 when they followed it up with a question and answer where they told schools exactly how to comply with their wishes. And then an often not talked about letter, a 2016 transgender guidance. The reason it's not often talked about, I'd say it's the most controversial for its content. It was rescinded very quickly because Trump was elected, and then that administration rescinded it. And then 2 years later, there was a Supreme Court case that many believe made it irrelevant, called the Bostock decision, which we can talk about later as well. So 3 basic ways things can formally be changed, but most of the changes have been made informally. And why does that matter? An informal guidance is not law. In practice, it is often treated as law. Why, you ask? Because the Office for Civil Rights, if they say, we're now interpreting Title IX to mean you have to have a certain kind of investigation when someone claims sexual harassment by another student. And by the way, you need to follow all of these procedures and hire this many persons to do so, and so on and so forth. Why is the college or university going to comply? Because they will lose their federal funding if they don't. And that federal funding means student loans. And if students can't get their federal loans or Pell Grants, they're not going to be able to afford college. Not to mention all the other aspects of the university that are funded by federal money as well. So you have something that is not law being enforced as if it is law. And I would say furthermore, we may not know who our congresspersons are, but I can assure you, we do not know who these bureaucrats are. These are appointed. You probably never met them. You probably don't care because bureaucracy tends to be really boring, and we don't want to know what's going on behind the curtain. So you have appointed officials interpreting what laws mean, putting it forward to colleges and universities across the country as if it is law, enforcing it as law, and then determining if the schools have violated it, and then giving the schools punishment, determining what their punishment should be. That sounds like a blending of executive, lawmaking, and judicial power in one set of hands to me, which James Madison in Federalist Paper 47 called tyranny. The uniting of all powers in one set of hands, whether one, a few, of many, he says the very definition of tyranny. That's paraphrase, but it's right at the beginning of Fed 47. So that's one reason to be concerned. A dear colleague letter or an informal guidance versus a formal guidance. Again, just a little more on why this matters. A guidance document where the Office for Civil Rights is telling you, oh, here's how we're interpreting athletics policies. We're going to give you 3 ways you can comply, and we're going to punish you if you don't. It isn't a formal law. It does not deserve the same deference as law because it can be changed tomorrow if someone else walks in and says, no, we're going to scrap that and interpret it this way now. And so it creates a malleability to law and can create confusion in law, which can be problematic. A guidance is not fixed. It's not settled law. Universities have to plan their budgets years ahead. If these things change frequently, and make no mistake about it, you change a rule relating to athletics or how you're supposed to handle sexual misconduct, that's going to cost a lot of money. That's going to have staffing consequences. Athletics is a multi-million-dollar industry, especially at the big football schools. So you can be sure if they're changing those things back and forth, that's going to have economic repercussions for universities as well. On the other hand, a formal regulation goes through comment and notice. It goes through deliberation. It is required to be compliant with the law itself. And so that is constitutional in the sense of conforming to rules and procedures, and deserving that deference that an informal guidance would not have. All right, so let's now take a look at the ways in which these three regulations have violated process, right? So you have the 1979 athletics interpretation, a quote unquote policy interpretation. It was published in the Federal Register for notice and comment. They did collect some comments, but they did not go through the full procedure. And so it is not, in fact, a formal regulation. The 2011 Dear Colleague letter on sexual assault was caught universities by surprise, as did the 2016 Dear Colleague letter on transgender students, which basically mandated universities to treat a student's gender identity as if it were a student's sex. Now, why, you ask, does that matter? The consequences of it were that it desegregated bathrooms, locker rooms, residence halls, and make no mistake about it, sex segregation is permitted by the letter of the law in Title IX. The implementing guidelines say separate locker rooms, bathrooms, residence halls are permitted under Title IX, as well as, by the way, all organizations for all females and organizations for all males were also permitted under Title IX. The 2016 Dear Colleague letter said those were no longer permitted, as it also raised questions about segregating athletics on the basis of sex. And if you all want to talk about that at the end, that's the current hot button question relating to Title IX is whether a transgender female, someone born biologically male, but who has transitioned or transitioning, or who simply identifies as female, whether or not it should be permitted for them to play on an athletic team with all females. The letter implied you had to permit that. No debate, no comment, no nothing. These highly controversial and charged issues need to be debated and need to be find compromises. Why? Because of the controversial nature of the divisions that we have on them. It is much more safe to have that deliberative process play out. I would say, look, we can look at two main reasons why. Just making a change to the law quickly, you may be completely on board with the content of the 2016 letter, with the content of the 2011, or the content of the 1979 three-part test. You might say, how else are you going to measure fairness in athletics if not by the numbers? That's a very strong point that can and should be made. But here's the problem with doing it in this way, with violating established laws and legal traditions. These are created, the Constitution itself, laws, be they good, be they bad, they're created through the will of the people. That's what gives them their authority. The Constitution and the laws that are enacted in a constitutionally legal way embody the will of the people. That's us. To disregard such institutional safeguards, to disregard the separation of powers, to disregard the notice and comment process of the Administrative Procedures Act, this is to reject the people's will and to challenge it's getting late, to challenge the legitimacy of our republic. And I know that's a high-minded way of looking at the problem, but I have a much more concrete reason why these anti-constitutional means are problematic. Sorry, didn't mean to jump ahead here. In a more tangible way, think about why one wants to use an anti-constitutionalist means or process. I'm not getting justice quickly enough for transgender students. Transgender students are suffering. They're being discriminated against. Nobody wants to see or hear that happen, okay? All rational human beings would agree that to impose vileness on individuals simply because of what their sexual identity or their gender identity happens to be is wrong, right? So, I want to get a quick fix. I want to get this written into law quickly. Doing it that way erodes the public trust in our institutions and our laws. And I have to say, I've had this point in here written for a week. And as I'm driving over here to set up in my office for tonight's talk, I hear on National Public Radio, the guest who's just written a memoir, he's a state attorney, said, America's trust in our public institutions is eroding. And I would say a key reason why is that people in positions of authority, whether they're bureaucrats or elected officials, think it's okay that they disregard the law for the sake of the end that they wish. How can we trust the law if our leaders think they can ignore the law when they wish? And I'm going to put it in a very basic way. I'm influenced by Lincoln's Lyceum Address. Do you want to live in a society a constitutional republic that's built on the notion that there are settled laws that apply to everyone, a society built on the rule of law, the Constitution being the law of the land? Or do you want to live in a society that is lawless? That's it. Rule of law or lawlessness. They're really, what's the in between? When you say, the Office for Civil Rights, they're the experts, they can ignore the law today for the end that I want to seek. If you admit that in that case, you really don't have an argument against anybody else breaking the law when they think that their notion of justice or their end goal is more important. Such disregard for the law, according to Lincoln, alienates even the best citizens from faith in even the concept of law, the Constitution, the National Republic. Today's Constitution Day. Saturday was, but we're celebrating it today. It's an important day to think about what that means. Why do we celebrate the signing of the Constitution? I actually do ask, why not the ratification? Why the signing? But we celebrate the signing of it. That signage signifies the will of we, the people, that this is going to be the law of the land. And that the people we entrust to hold those posts that are described in that document are going to create laws that are imbibed with our will because we ordained it. If those leaders ignore the law or say they have a better code than what's written in law, what are they operating on? All right, so that's why these things are problematic. I would say all three of these also have substance that's anti-constitutionalist as well. I'm only going to very briefly talk about this moved quicker than I meant it to. The anti-constitutionalist ends. The idea of numerical parity, that mirroring the population, as I already said, the original Title IX called into question whether that was preferential treatment or not. I would add to that that there was a ban on quotas in the original, and we can debate whether or not that's a quota. What I'm more interested in talking about is the second one, the 2011 letter. It altered the standard for what constitutes sexual harassment. So prior to the 2011 letter, the requirement for constituting actionable sexual harassment under Title IX, it had to be pervasive all right, meaning more than once. It had to be severe, and it had to be patently offensive by a rational observer, objective observer from an objective standard. The new standard was much more extensive notion of unwelcome behavior that didn't comply with the Supreme Court's previous standard set and moved into areas of speech and behavior and expression. The 2011 letter also mandated a parallel justice system. In those 37 words that I read at the beginning of this talk, there's nothing there that would indicate this is what the law should or could require. So I'd say it's not evident in a common sense reading of the law that this is something necessary. Even if it were, even if you granted, yes, we need to try cases of sexual harassment on campus. I think a lot of people are very comfortable with that notion. The evidentiary standard posed a problem for a lot of folks. They required the preponderance of the evidence standard. The previous standard that most universities had used was called clear and convincing. Preponderance means 50% plus a feather. Clear and convincing is more rigorous. You're probably familiar with in a criminal trial beyond a reasonable doubt. That's extremely difficult. And the sad fact about sexual harassment, sexual assault cases, it's very difficult to prove beyond a reasonable doubt. So often survivor victims don't get justice and violated due process. So I would say, just to make it simple, because I'm assuming we're not all constitutional law attorneys in this forum tonight, due process is a menu of items that help ensure that someone who is innocent is not wrongfully convicted. And there's some wiggle room within due process, but in general, you're talking about, if you're looking at a criminal case, your right to have an attorney present, your right to speak in your defense, your right to hear the charges against you. So I would say combining the lowered evidentiary standard with the fact that the procedures required by the Office for Civil Rights did not permit an attorney, did not permit those who were accused to hear evidence that might be exculpatory. There were a number of questionable requirements in that letter that violated standing law and due process. And that, by the way, is why the 2020 formal regulation was passed in order to correct those shortcomings. Those are the reasons, those content-related problems, why there are 800 cases pending. Some of them have been resolved, but those are all on individuals who say, I was accused of sexual misconduct or I was accused of sexual assault, and my university did not grant me an attorney. I was never able to face my accuser. I was never able to hear the actual charges before I was sentenced. I was kicked off of campus before there was any hearing. Those kinds of things. And again, I'm going to leave for Q&A for you to ask me some of the details on that, because it's, believe me, rich for conversation. The 2016 letter violated constitutional ends because it failed to comply with following the meaning of the words that comprise a law. What they did with this letter is redefined the concept of sex, and they replaced it with a new concept, quote unquote, sex assigned at birth. So the concept of sex assigned at birth, if you're assigned your sex at birth, that means you're not born with a biological sex. And so for simplification, I'm just going to say those are two different concepts. And to replace the word in the law with that second concept, which is a new concept, is changing the law in very fundamental and significant ways. So the ends, not only the means, are anti-constitutionalist. So let's get positive here. Let's end on a positive note and talk about the ways in which we can restore the constitutional integrity of Title IX. And I would say these final remarks do not just apply to Title IX. Look at some of our most ugly and bitter disputes at the moment. I think in many of them, what you're going to see is one side accusing the other side of not following basic law and saying the law should apply to everybody. If you're going to apply it one way to one person and a different way to another, that's not constitutional. So in practice, here's what we need to do. Public officials, they need to adhere to the separation of powers. They need to adhere to the sharing of powers where it exists. We need to look at the enumeration of the limited powers and respect that. We need to look at the prohibitions imposed in the body of the Constitution, the Bill of Rights, and in the amendments, right? These are important guardrails for what the lawmaking process can and can't do and what the content of a law can and can't do. If you think of the Bill of Rights, just because one can pass laws doesn't mean the law can have any content whatsoever. The Constitution sets the guardrails, getting the authority from those guardrails from we, the people. Appointees must also follow laws that are passed by Congress, like the Administrative Procedures Act. These procedures don't exist to be annoying or frustrating, even though I'm sure they are very annoying and very frustrating. The notice and comment procedure, for example, that allows public participation in the process. These laws get their authority from the public and they're imposed on the public. Shouldn't the public be involved? They get to share their concerns and have an impact. And in getting those comments, it also forces administrators to compromise. If these legal mandates become pernicious, lawmakers can pass laws to weaken them rather than just ignoring them, right? There's a real problem when our elected leaders ignore the laws that they themselves wrote. How are we supposed to respect our leaders? How are we supposed to respect the law if nobody abides by it? So what I would call the constitutionalist Title IX focuses on the constitutionality of both the means and the ends of lawmaking. It does not require a specific policy. The policies I spoke about, athletics, adjudicating sexual misconduct, there are ways to achieve goals under those umbrellas through constitutional means. All right, subject to the limitations of the Constitution, the national government can require or refuse to require an alignment of sports participation with the enrollment. It can require or refuse to require an establishment of a parallel justice system. You could pass an amendment to Title IX and say, this is now under the auspices of this law. Instead of a policy revolution by informal guidance documents or previous interpretations, Title IX would be made by Congress or the Department of Education using formal regulations. Now, my personal opinion is that it's better to force lawmakers to make laws. They don't like to do that because then their voting record is out there and it's going to affect them in the next election. But I think we need to force our lawmakers to make laws instead of having them done behind the curtain. In other words, a constitutionalist Title IX respects the democratic process. So just to sum it up one more way, two things absolutely required. Congress has to make laws on major policy questions. If there's a major change to be made, it shouldn't be made in a sneaky, sly, behind the scenes, informal way. It should be debated. It should force compromise. If compromise can't be had, it might not be the time for it. Second, when the Department of Education writes new regulations, they have to adhere to the Administrative Procedures Act. I would say these changes require a change in culture and a change in attitude, not just among our lawmakers, but among us. We get frustrated that our lawmakers don't do enough, don't get it done quickly. Well, the founding generation thought it was dangerous to move and change things too quickly. And there's reason to be concerned. If you want people to respect the law and you want people to respect their institutions, you need to do so through legally mandated ways. So with that, I'm going to open up for questions of anything Title IX. And if I don't hear from you regarding questions, I have a few questions that were sent to me from a forum that I understand some of you were involved in prior to this, in which you were discussing some of my previous writings.
Well, thank you so much for that presentation. I really appreciate it. I know our attendees appreciate it. And I do see some people are raising their hands too, and we've had some questions come in. If you did submit a question and you want to ask it live instead of having me ask it, just raise your hand and I'll come to you and let you ask it yourself. Our first question actually came from John Squires. So I'll give a chance here to see if John wants to raise his hand and ask the question, or I can ask it for him. Let me just give a chance to see if he wants to raise his hand. All right, well, I will ask John's question, but if you did type in a question, feel free to raise your hand. I can allow you to have your mic and camera on and ask it yourself to Dr. Busch. John asked, with name, image, and likeness being prominent in college football, is there a position by Title IX advocates in regards to female high school or college sports?
In regard to email?
Name, image, and likeness, which is the name, image, and likeness is that new way of athletes to make money.
Right. No, I'm aware of that.
Okay.
And boy, this is an instance where I wish my co-author was with me because his expertise is in sports and Title IX especially. So there currently hasn't been any guidance. So this is an example of something that pops up that we might be desirous of having. Well, look, some are and some are not desirous of having government come in and tell you what it ought to be, right? Some would prefer to have the athlete themselves determine what's appropriate and what isn't. So from my limited knowledge on the sports front is there isn't a formal regulation yet. The Office for Civil Rights, or actually the Secretary of Education has said he is going to put out a comment on athletics, open it up for comment to make a formal regulation. Now, my understanding was the main issue that's going to focus on is transgender individuals and what teams they can participate on and what schools have to do to accommodate that. I am not aware that whether he was planning to answer that yet. So that is an area that needs to be teased out at the moment. And you might be interested to know also that some of the athletes who are making the most money on these things are not necessarily the top athletes, but sometimes the most aesthetically pleasing athletes. Let's put it that way.
Mm-hmm. Absolutely. I'm going to jump over to Jalen Burton and allow her to talk because she has her hand up and has a question. And so, Jalen, you can unmute yourself and turn on your camera if you want and ask the question here.
Okay. Hello, can you hear me?
Yep, absolutely.
I don't know how to turn on my camera, but my question is, what you mentioned the Supreme Court a couple of times. Can you give examples of the Supreme Court being anti-constitutionalist?
So this goes back to one example. 1979, there was a woman who was not admitted to medical school. She sued. And the question there, if you remember at the beginning of the talk, I said the method of enforcement of Title IX is the administrative remedy, meaning the Department of Education comes in, investigates the school, tells the school how they have to change, right? And the threat is pulling federal money. The Supreme Court added the right of private action and added the right to sue for monetary damages, which was nowhere in the law. And I would say explicitly, Title IX was modeled after another law called Title VI. The language is almost identical, except that Title IX refers to sex, whereas Title VI refers to race, etc., religion, and so forth. Title VII, upon which it was not based, allows a private right of action. So one would think if you wanted to permit the private right of action, you would base the language on a law that already exists that includes that right. Instead, they did not. And so one could make the case that was intentional and did not allow for individuals to sue. Again, this is an example where one could say, well, maybe it's a very good thing that Title IX allows students to sue if they're being discriminated against. I mean, I think there's a very good argument to make. The question is whether the court should say that right exists, or whether Congress should say, yeah, we meant that right to exist. Let's amend it and fix it. And I would say it's much healthier for our public trust in our institutions for Congress and our lawmakers to do so. I hope that answers your question.
It did. I'm over here trying to type up what you said, but I heard it. Thank you.
Sure.
Wonderful. We do have another question here in the hopper here from someone who asked, what's the difference between sex and gender?
Okay, good. I was hoping someone would ask this. So sex, according to the World Health Organization, and a number of other organizations, refers to the biological designation of an individual. I think the easiest way to say it is gametes, chromosomes, and the relation of the organism with respect to reproduction. That's the technical term. It's just a biological designation. Now, in the case of humans, we have XX, we have XY. Those are the two primary. There's also XXX. There's also XYY. All right, so there are other you could say sexes, right? Those rarely occurring ones tend not to have a role in reproduction because they often cannot reproduce. Because of the existence of these extra chromosomal designations, the term gender was created by a doctor. His name was Money, oddly enough, sad but true. And he created this term to help individuals say an XYY, where it may not be immediately clear whether the male or the female traits are predominating. And so you would, in these cases, need to assign a sex, right, to those individuals. So gender refers to the roles we attach to sex. It's also a sociological term. You're going to find it in anthropology textbooks, probably also in intro government textbooks. Gender refers to the social meanings of sex. Gender, by definition, is not a fixed term. In different times, we may conceive of females in one way, and different times we may conceive them as others. So this is called the Tocqueville Forum. So I'm going to use Tocqueville as my example here. In his section on males and females, within and of itself is worth a lot of conversation and scrutiny, because it's I almost said the one, but it's one of the areas where his prediction is totally wrong. He predicts women are going to stay in the household, that men and women are going to maintain separate roles. When you use the concept of role, R-O-L-E, you're using the concept of gender, right? That, oh, if you're a woman, you should want to be pretty and you should dress a certain way and wear high heels, etc. And if you're a male, you should not do those things. So when I think sex, I think male, female. And when I think gender, I think femininity, masculinity, maybe man, woman is more in the gender than male, female, if that's helpful. But the two terms are used interchangeably erroneously. They're not interchangeable, but the practice of using the term gender, so someone will say, what's your gender? And you say male or female, or I'm non-binary, or whatever you might say. Gender does not mean the biological XY role in reproduction. Gender means, how do you perceive male? How do you perceive female? How do you identify those things? What roles should they? And so it is not correct to use them as if they're interchangeable. We started the habit because sex also refers to intercourse. And so people were desirous of another term. So that's something I would say as a society we need to figure out. We need to be more precise in our language, because this isn't working for us right now. And it's creating a lot of confusion and problems in public policy and in conversation.
Thank you. Thank you. I'm going to allow Ollie here to talk. He's got his hand up. And I do remind you, too, that if you have a question in the hopper and you would like to ask yourself, feel free to raise your hand. I'll come to you. Otherwise, I'll return back to that. But Ollie, you can unmute yourself and turn on your camera if you want and ask your question.
Yeah. Hello, Dr. KB. Bravo. Have there been any serious efforts in recent years to address some of the controversial aspects of Title IX at either the congressional and executive levels?
Well, so there has been an attempt to pass something called the Equality Act that would do some of the things that people are using Title IX as a vehicle to do. It did not garner enough support, as you could imagine. Congress right now is very divided. And just a little perspective, it's not new for it to be as divided as it is. It has been uglier in other periods of history, but there's this particular zero-sum game notion going on in Congress that compromise is seen as weakness, problematic, and people don't want to compromise. So I would say, yeah, there have been efforts, but not widespread. There's been a notion that bureaucratic agencies are comprised of experts. And don't you want the experts interpreting the laws and telling us what they mean? And they're going to do the right thing because they're the experts. From a constitutional perspective, I say this is problematic because they may be an expert on a topic, but they're not an expert on compromise and what the sentiment of the population might be at any moment and how best to achieve the results they may want. The road to hell is paved with good intentions. So I may have a good intention of protecting sexual assault survivors. I don't think anyone would dispute that the 2011 letter brought needed attention to a problem on college campuses, particularly big athletic school campuses. I think if you look it up, you'll see there's been neglect in horrendous ways. So let's say I want to fix this problem. My question is Title IX the vehicle to do that? And how best to do it in a permanent way? And what happened in 2011 was they were a bit overzealous. They, you might say, overcorrected and provided too few protections of those accused because they wanted to provide justice for survivors. I don't think anyone's against justice for survivors. But what they ended up doing was hurting the survivors and the victims of sexual misconduct, because there are 800 cases now of these accused students suing their universities. And those accused students may or may not be guilty. I don't know, but they didn't have a fair process, theoretically. So we don't know. So that actually hurts the victims and it hurts the winners and the losers when you do it in an anti-constitutional way. So I'd say there's been a history of just deferring to these agencies. And what you're seeing right now is that the Supreme Court's looking at some of that and saying, when there is a major content issue, Congress is the one that needs to take a stand. It's really going to take our culture that has to change. I would say another area where you see this deference is in war powers. And over the last 20 plus years, since September 11th and a little bit before, these congressional members don't want to take a stand on a controversial military engagement. So they step aside and let the president take unilateral action, which is sometimes misguided. So, there are some examples of Congress trying to do so. And if they fail, that just means they need to work to compromise a little bit better. We have the wrong people in there. I mean, maybe I'm idealistic and naive, but I'm not willing to give up on our constitutional system yet.
Bravo.
Thank you. Is this the Ollie that I know?
Yes, ma'am.
I thought so.
I would have turned on my camera, but I don't see the option to do so. It's great to see you, Dr. KB.
Great to see you too. This is one of my best students I ever had. And he took my class while his mother was undergoing the citizenship exam, and he's a true patriot and great American.
The feeling is very mutual, Dr. KB, and if I may say, this is one of the best professors I've ever had, by far.
I did not pay him to show up today.
I saw another hand up there. Addison Merchant had a hand up. I'm going to allow Addison to talk here if Addison wants to.
Hello.
Hello, I can hear you.
Hi. I posted my question in the chat. So, but I can ask again. I said
Yes,
a lot of
please
people,
do.
including myself, don't understand the full importance of Title IX and how it really affects us. So what can we as students do to understand the importance of it?
Okay. Do you mind if I ask you a question? It'll be a
Yeah.
simple question. Have you had to do any Title IX training as a student?
No, ma'am.
Have you had to go to any Title IX presentations of any sort?
I don't think so.
Okay. So I'll use my university as an example. If we were talking in 2010, I would say most students would probably not have heard of Title IX unless they were an athlete. So Title IX requires that the number of athletic spots at a university mirror the population of male to female ratio, as I said earlier. Consequence of that is a lot of money spent, right? That's going to affect scholarships. It's going to affect recruiting. It's going to affect how many spaces for how many students. So that all is important, all in theory. It's definitely important to athletes. And so on the one hand, it's expanded intercollegiate athletic competition for women. Now, there are some who dispute whether it's Title IX that did it, whether it would have happened naturally on its own. I can't predict whether it would have happened or not. I'll leave those to the statisticians. But that's one reason why it's important. And so, when you see an female Olympian, they will often tell stories about their athletic competition because of Title IX. So it's definitely done that. I would say the experience of coming into a classroom and seeing a female professor and not being surprised by that. Prior to Title IX, a university could say, yeah, we don't want to interview you because we don't want a woman in this post. And that was perfectly acceptable before Title IX. So a lot of the benefits conferred seem completely normal to us, so we wouldn't know what it felt like to not have them. I took shop class in middle school. I was petrified by it, but I had to take it. And I got to cut things with a chainsaw and all this stuff. Prior to Title IX, that would probably not have occurred in a lot of places. So, all of that. But here's where it's really important today. It's important and you really do need to educate yourself on this. This letter in 2011 on managing sexual misconduct allegations on college campuses. Prior to that, sometimes when these things happened, it was hush hush. They were handled well or poorly. This tried to bring attention and have some sort of process to it. What it ended up requiring is that campuses set up a sort of criminal justice system on campus. That was never part of the law at all. Now, here's what's interesting. The formal regulations in 2020 replaced a lot of the faulty procedures I mentioned, the failure of due process protections in a lot of ways, but they took for granted that a parallel justice system exists. So the 2011 letter was extremely successful in changing the culture of campuses to require a justice system for sexual misconduct allegations among students. Okay, so that should be said. This informal letter written without following the APA changed every single campus across the country, except maybe the 14 who don't take any federal money. The due process requirements under the 2011 law, and we don't have a ton of time to go into all of those protections, but I'll say the mandated procedures with the evidentiary standard that was lowered caused problems for students accused of misconduct in this way. They argued, oh, this isn't a criminal trial. You're not going to go to jail if you're found guilty on campus. But if I'm charged, let's say I'm a student and I'm charged with sexually assaulting someone, and they did not require a strict separation of investigating, prosecuting students. They allowed a single investigator model. They did not require students to be given an attorney. They did not require students to hear what the charges were. Collectively, all of those together, if you're a student accused of sexual assault, are problematic. You don't have enough protections. And the upshot is you weren't necessarily presumed innocent. It was believe the survivors. Legally, that isn't the way our system is mandated to operate. And so as a result, let's say I'm accused, I go through this single investigator process, and I'm found guilty, but I insist I didn't do it. My school will expel me. In Virginia, it's put on my record. So if I try to go to another school and try to get admitted, they're going to see that record and not admit me. Basically, I'm blackballed from going to college. My life is altered tremendously. Given the high stakes of being found guilty of a sexual assault or sexual misconduct, a hearing with adequate procedural safeguards is absolutely necessary to comply with due process. A meaningful appeals process, an attorney, no single investigator model is important. So why am I stressing all of this? The 2020 regulations put those things into place. Here's what you need to know about Title IX. As we speak, actually 1 week ago today, the comment period closed for new regulations altering the investigative process, going back to the 2011 guidelines for the most part. The person who wrote them was in place, was in office, not at the high post of Assistant Secretary for the Office for Civil Rights. She now is the Assistant Secretary for Civil Rights. So this has been proposed. There were thousands and thousands of comments, and we're going to have to wait and see whether we go back to those weakened due process. Now, why do you need to know about this? If you are a survivor or if you are accused, it matters to you, because if you're a survivor and your accuser is found guilty under a faulty process, they might sue and you might lose your justice. And if you're a student who is wrongly accused, right? That's going to upend your whole life. And even if you sue and you win, so winners and losers are going to be corrupted by the process. So what's going to happen if they put those weakened due process regulations back into place? No one can sue until a wrong is done. No one can sue till a wrong is done. So we have to wait and see what happens. And so I would say every single student who ever utters anything relating to sex, gender, pronouns, anything, theoretically can be brought up on a charge, because their notion in these new regulations that may or may not withstand the notice and comment expands greatly the notion of unwelcome behavior. They take away the repeatability factor. It can be a one-time thing. And they take away the offensive, objectively offensive standard and change it to subjectively offensive. And so that could mean speech. It could mean any number of things. So if you're concerned about free speech, free expression, if you're concerned about sexual assault, sexual misconduct survivors, you need to be aware of it right now. Sorry to be so dark, but.
Addison, that help to answer your question? I'm gonna assume it did.
She may have muted herself.
Yeah, absolutely. It's very hard. Look, I get it with Zoom all the time. We forget everything about that. We've gone back to in person mostly, right? So how do I work this Zoom thing again? I want to ask a question here we got from Lance. Lance asks, I very much like the idea of constitutional changes to Title IX. However, gerrymandering has wreaked havoc on our electoral processes. Those representing us in many cases don't reflect our voices. Furthermore, intense partisanship seems to get in the way of legislative conciliation. These realities make constitutional changes to Title IX seem far less attainable. How do you respond to this line of argument?
I mean, I think you're right. It's very hard. So here's where I come from. This is the system that we have. It has sustained for 235 years. There are serious problems with it. We need to fix it. We can pass amendments to the Constitution. We have to do it if it's necessary. I think the worst thing we can do is say, oh, it's okay to ignore the parts of the law I don't like to get this in. That's called the ends justify the means. And how many people do you know that you want to decide which laws they obey and which laws they don't obey? I'm much more comfortable knowing what the law is and that everyone's going to abide by it. And so I would recommend, sort of as an answer to this question, Lincoln's Lyceum Address. Then I would secondarily say, let's think about what it means to represent my interests. That may not mean my lawmakers doing what I want all the time. And we do have the ability to move somewhere else if we don't like the way our state runs. Now, that's not an easy thing to do. It's not easy to get up and move your family, but we need to start thinking about the way we as individuals and we as groups are empowered to make changes. Again, I think it's going to require a cultural change. If gerrymandering is done in an atrocious way, then one can lobby to change a law within a state regarding how they carve up their districts. At the state level, you actually have more authority than you do at the national level. And at the local level, even more so. I have a neighbor who's running for mayor, so I'm hoping to learn a lot about very local politics from this individual, down to, very simple things like he didn't put his face on his poster, but his opponents did. And we told him, you're a handsome guy. Why aren't you putting your face out? He said, but I look really young. And we determined if I look too young, I can't run for office. So your point is well taken, and I'm not even disagreeing with you that there are some areas of the country you can live and be opposed to the sentiment, and feel like the vote's never going to go your way. I would say you might consider moving, first of all, but secondly, I think in practice on a one-on-one basis, we can affect some change. So, I find this constitutionalist, anti-constitutionalist paradigm a way that opens up meaningful conversation with people who don't agree with each other. I mean, my husband and my in-laws are diametrically opposed politically, and we had a very, I'll even say it, pleasant conversation about politics through the lens of this paradigm, where we weren't bringing up individual names, but we were agreeing that everyone should follow the laws. And the one interlocutor thought they were criticizing the other party, and the other thought they were criticizing the former party. And I think that's a first step, is that these are different worldviews, and we need to get back to talking on the same plane. Whether it's Title IX, I mean, the things that I've said about Title IX apply to all of the executive agencies. And, there's certainly some ways in which, if you're talking about the EPA, particles per milliliter of pollution, I have no opinion on that. I'm not a scientist. But, if you're talking about, what's a fair athletic policy to provide equal opportunity, I can talk to you, and there's a range within constitutionalism where we can disagree. And my point is, we need to get back to recognizing what the law is and what it isn't. Then we can have the policy disputes. But right now, we're so busy being bitter against each other for flagrantly violating the law that we can't even have the interesting debates over policy disputes.
Excellent. Hunter has a question. I'm going to unmute him, allow him to talk. And this may be your final question. We'll have to see. But Hunter, okay. You are allowed, or you are open to talk here.
How are you doing tonight, Doctor?
I'm good. How are you?
I'm doing well. My question was posted in the chat as well, but I figured I would ask. So in regard to transgender and LGBTQ athletes, particularly in the college setting, do you believe that the integration of designated, like in the traditional sense of men's and women's athletic teams, is a solution that awards equal opportunity for all the parties?
So I'm glad you asked that question, because I always start by saying I'm not a policymaker. I get to point out all the problems. I don't have to make a solution. But I actually think the solution is reframing that question. And I look at it this way. Athletics have been segregated by sex because of the fact that the bodies are different. And that if, for example, in running, you had males and females running against each other, males would always win, right? If you're talking about the top athletes at the top of their game. There is an ease with building muscle mass on the side of XY. There is a vulnerability to injury and bone breakage. There's greater vulnerability on the XX side. There is a universal agreement that athletics has important educational benefits for people, no matter what their sex, gender, identity happens to be, that athletics is a great supplement. I have 2 children who are athletes, and I'm learning a lot about how trying that can be. Here's the question that I ask to think about the problem. So we have segregated athletics by sports. If the question we are faced with today is this: is there a benefit to allowing females to XX individuals to compete against XX individuals or not? If there is a benefit to that, then it should be defended. If there is not a benefit to that, then we don't need to have it, right? So we need to look back at why did we segregate in the first place? And it's because you wouldn't have meaningful athletic competition for the XX sex if you didn't segregate. So when you're talking about whether XY individuals who identify as women should compete against XX individuals, you have to ask, what is the reason why we have XX competing against XX? And it is to avoid that vulnerability to injury. Now, I believe there is a sport that allows males and females to compete. It's equestrian sport, I believe. So that's the question we're faced with. If there is no benefit to female sport as such, then we don't have a conversation. So that's, to me, the meaningful debate that needs to be had, not whether this individual should be allowed on that team or that individual should be allowed on that team. Is it going to be chromosomally segregated or not? And is there a benefit to XX competing against only XX? Does that make sense?
It does. So do you believe that athletics should be defined by sex and not gender?
I'm saying it currently is defined by sex, and it has been defined by sex. And so you have to ask why. And the reason is that the biology of XX is different from the biology of XY in such a way that it has been deemed that XX wouldn't confer the benefits of athletic competition were they not allowed to compete only against XX. Right? And so if you don't agree with that, then that's the conversation to have. But that's always been the basis for separating the two. So could our society move to a paradigm where we have just co-ed sports? You could. That would look very different. Is it going to confer the same benefits? My son in middle school, their soccer team is co-ed. What would the Olympics look like if athletics were only co-ed? Why do we have them separate at the Olympics, right? Do we want to see the best female sprinter competing against the best male sprinter? Is that going to be an interesting competition? Or we could then ask, what's the role of sport in our society? Why does it matter? And those are the questions that have to be asked. And I think we are uncomfortable with explaining why we separated the two. But I think if you use my term of chromosomally segregated, it becomes a little more clear and a little less passionately charged. But I didn't give you my opinion, and I'm not going to.
That's I completely understand.
What's your opinion on it?
And I think
or
there's his mic. Sorry, Hunter, your mic dropped off there. So
I'm sorry. I believe since there's growing pains with figuring out how to properly do anything, and we may never know if we ever find the perfect solution to integration of or competition between the sexes, or just the definition of identifying qualities of who you should compete against. And I think you'd agree that there are some advantages and disadvantages between each of the two parties, and just seeing some examples of there being XX athletes competing against XY athletes, and I don't want to say taking advantage of, but competing maybe more successfully.
Well, I mean, the swimmer, right? The swimmer,
Yes,
that's the example. And there are also some runners that we're
powerlifting,
familiar with.
other things, and maybe those aren't as regulated, but or just defined in the rules of competitors. But I'm just wondering if where does the definition of who is allowed to compete in, like, what level of competition do we define that?
Yeah, so to bring it back to our conversation, right?
Mhm.
So the NCAA, the National Collegiate Athletic Association, has been, they have rules that pretty much universities comply with. And I don't know enough about the history of that organization to know, like, why is that? So they're the one who, was defining and is currently defining them. They've always been pretty generous in terms of inclusivity. One thing that is certain on this question is that there is no way to accommodate every single person's interests and desires on it.
Absolutely.
And I think getting back to constitutionalism, a fundamental foundation is a particular view of human nature, that human beings are not perfect. And if you read Fed 10, we can be selfish sometimes, but above all, we're not perfect reasoners, and we come together and align in groups for passionate causes, and that can make us even more unreasonable sometimes. But we are imperfect, and we are the source of our system, and we're also running our system, and our solutions aren't going to be perfect either. But that's also why conversation and compromise is so important. We need to face this by being honest about it. The word sex, in terms of its meaning, has not changed. The concept has been stable. The meaning of gender is a much younger word. And so, one of my other book projects is called How Sex Became Gender, looking at how we're trying to transform the one word into the other. And it's not just happened in medicine, it's happened in history, it's happened in politics, it happened with the consciousness raising groups of the 1970s. So, that's why, in a very fundamental sense, we can ask, what is a law? And what does a law mean? And you have to start with, it's the words that make it up, right? So yeah, it's going to be an uncomfortable conversation we have to have. And if it's not an uncomfortable conversation, it's going to be people slyly trying to change rules in ways that are quick and easy that will make the problem worse. And without opening up a can of worms, and let's just agree we're not going to talk about this, but I think abortion policy is an example of that kind of nastiness and bitterness. That was a conversation stopper.
Well, Hunter, thank you for your question. Did that help answer?
Question.
Yes, it did. Thank you very much, Doctor.
Well, I would love to stay here all night. And in fact, I cannot, we have 25 questions in the hopper still.
Oh my goodness.
I know, we have 25 questions. We have hands up. So may I make a proposal? And Dr. Busch can tell me if this is too much. But if students still want to ask questions, can I ask them to send me an email to take their questions, to centralize it, and perhaps you may have some time, not now, not in the next weekend, but over the semester, just to look at those questions and send it back, and I could share it with those students, your responses to their questions. Would that be okay?
I'd be happy to. I would love to continue the conversation.
Well, I think this just means we need to bring you to Jacksonville State at some point here.
I agree. I would love to come.
I think we just got
Constitution Day week is a very difficult time for me to travel.
Especially on the 50th anniversary of Title IX. So we do appreciate that you are coming to us in any means that we can get you. And we do appreciate you helping to educate us on us. I can't tell you the number of students who said, I only thought Title IX was about this topic or that topic. And so we very much appreciate you. We appreciate the Jack Miller Center and the American Democracy Project at Jacksonville State University for helping to fund this and for giving us the ability to have you here tonight. I said, we will have to bring you back. I do ask, stick around after the presentation. We will have a quick survey. So you can answer some questions, give us ideas too. If you want to follow us, you can follow us on Facebook to see upcoming lectures, upcoming events, or rewatch. We'll have this on YouTube soon, and you can also watch it on our Facebook page. But I said we'll have to get you in person because being it together, there's something that happens when we're together talking that we don't get.
I would love to come out. I mean, these have been great conversations and great questions, and very impressed with your student engagement.
Well, we are too, and we are very lucky to have such great students here, and we're very lucky to have you get to engage with them. So I said,
let me close by saying you guys have a gem in this professor. This forum that he's organized, really impressive and a great opportunity. So appreciate it while you've got it.
Well, and I did not pay you to make such statements, or we didn't even pre-plan that. So no, I appreciate you praising the Tocqueville Society that we're working with, and the lecture series here, and all the good work that we're doing here. And so I said, we will have to get you down to campus, not during Constitution Day week, and come visit us maybe in the winter months where it's more temperate and mild in the state of Alabama. Well, thank you everyone for joining us tonight. Thank you again to the Jack Miller Center. Thank you again to the American Democracy Project. Please follow us on Facebook for more information. And please join us for our next lecture on Thursday, October 20th. We'll be having Dr. Brandon Stewart from Troy University come speak to us on disinformation and the threat to democracy. He recently co-edited a book on NATO and has been to Eastern Europe and did field research in Eastern Europe. And so his talk is going to be focusing primarily on authoritarian governments like Russia, and how these authoritative governments and authoritarian governments use different disinformation to try to threaten democracies around the world, like the United States. So we hope you can join us for that. Thank you everyone again for joining us, and we look forward to seeing you in the future. Have a great night. Bye.